One of the fellows, Joe, deals with vacation Nicholson, I go down and look. The other half of that, made a very amazing point. Wanted to evade dispute by the gallows. Not dispute, like that. Okay, not dispute. It's time. It is time to better. Good point. Okay. I got that. Very fun. All right. Honorable Mary Gardella, Judge, presiding. All persons having been before the court solemnly give attention and will be heard. In God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 6th District Court of Appeal. We have two cases on our docket today. As our marshal said, I'm Judge Nardella. Joining me to the left on the panel is Judge Brownlee, and to the right on Judge Wozniak. The first case that we have today is Brian, and please correct my pronunciation, is Brian Sagmacy Meralda, and I'll say et al. Versus Stafford A. Mitchell. Counsel for appellant, you're provided 20 minutes. You have rebuttal if you choose. We have it pre-designated set at 5 minutes, but we can increase or decrease that depending upon how much time you'd like to reserve.
I'll reserve 5, Your Honor. Thank you.
Counsel, whenever you're ready to proceed.
Morning, Your Honor. May it please the court. I'm Jeffrey Geldens from Lewis Brisbois here on behalf of the appellants. We're here on appeal of an order granting leave to plead punitive damages, which, as we know, is governed by a statute, section 768.72 of the Florida statutes. There's language in that statute that I'd like to take the court through because obviously our claim of error is that the trial judge was not fully faithful to the language of the statute itself. The first element I'd like to address is the presumption against punitive damages, which is based on the word unless that's in the statute. It says that you can't plead punitive damages unless, and the presumption requires the plaintiff to come forward with evidence. And that character of that evidence is also defined in sub 2A and sub 2B of the statute. But importantly, what that language means is that there must be some level of willfulness or consciousness beyond just a general risk. The cases use various ways to describe that. They say negligence, they say criminal manslaughter. It has to be something beyond just harming the plaintiff. And it's not even the scope of the plaintiff's harm. It could be a really bad thing, but it doesn't necessarily mean that it warrants punitive damages because punitive damages are reserved for the most egregious of behavior. The cases that we cite for that, including one from this court, Mercer, which says that negligence is not enough, are clear that you have to do more than just show that they breached a duty or that they did something else. I'd like to point to some of the evidence in the record that was relevant to that position below, which the trial judge misapprehended. The first is in the appellant's appendix at 278, Mr. Sagastini, the defendant, says that he had done this without incident in the past. And there's a case out of the fourth, which is our summary or supplemental authority, which addresses the idea of, if you're trying to be safe, if you're trying to do things and acting in good faith, that's not the level of egregious conduct that would warrant punitive damages. There's also in the appendix.
Sorry, counsel, are you saying that that's in a depot and that was part of the plaintiff's proffer, or are you saying, or is that competing evidence?
So that's the second aspect. Thank you, Your Honor. That's the second aspect of the statute that I was going to address, and I'm happy to go there now.
Well, I just wanted to know, are you referencing if he says I've never done this before, is that in a depot transcript?
Yes,
Is that
it is, in the
appendix
record.
278? Okay. And then was that proffered by the plaintiff?
It doesn't have to be proffered by the plaintiff.
Well, counsel, we understand the statute. There's a proffer component and there's a record component, and there's a debate over whether or not the record is in total put on by both parties, or if the record can only be what's put in by the plaintiff. I think that's a current ongoing debate that may or may not be resolved by Perlmutter.
Well,
So I think correct me if I'm wrong, I think what Judge Brownlee is saying is, we haven't taken a position on that, but help us define the scope of what evidence we're looking at. So where should she categorize that?
so the first thing is categorize it as the record first. So that's the
Sure.
question directly. But more importantly, this notion of a counter proffer is really just it's nomenclature because the record is
The record is the record is the
We're
record.
talking about what's the statutory language. This court and plenty of other courts in Florida have talked about what the mission of courts is, and it's with regard to statutes, and is what do these words mean? And it says proffered by the plaintiff or in the record. And so this is in the record. And to that end also, there is.
Is that, and so in your mind, it seems obvious to me as I ask this, but if it just says or in the record, that's different than wholesale acknowledging a sort of rebuttal proffer offered by the respondent.
Correct. As I said, I don't think that the statute really contemplates presenting and rebutting. I think it just says as a record. You can choose to say that's the evidence, plaintiff, and it's not good enough. But you can also say, plaintiff, that's not all the evidence. The record includes other things. I know some cases before this debate started had used the summary judgment standard to say, that's how we get you in the light most favorable to the plaintiff, because the plaintiff is sort of the movement on summary judgment. But that's really conceptually, I think that's really what the statute is calling for, is you look at what the record is. What evidence does the trial court have upon which to conclude that this conduct qualifies?
Okay, so your point would be that this is in the record and it's not weighing, because they're not saying that he's saying here, this has never happened in the past. They're not saying this exact thing has happened.
Right, because what that means is a legal question. Exactly.
But aren't they saying that if the plaintiff's position is this took place on December 28th and on December 30th, and then we look in the record and there is something where he says this has never happened before, are those conflicting in such a way where we would have to be weighing it in order to resolve whether that's true?
No, you don't weigh, and I'll take you back to the summary judgment type of standard, which is, you look at reasonable inferences and you look at the record. And so what you would do is say, well, number one, is that actually a fact that's in the record? And the answer to that is no. There's a specific piece of evidence that was filed in the record, which was from the Maitland Police dispatch reports that says a report was misdated. You also have the job tickets that were filed below, which say that this person was not on the job at the time. You, of course, as I mentioned, have the testimony of the defendant saying this has never happened to me before. So what you have is a stack of evidence that says the reasonable inference is that's a typo, and that it didn't happen twice.
Okay, so how do we, I understand all of that. How do we reconcile that with this affidavit, setting aside just the police report that may or may not contain a scrivener's error? And I hear what you say about the competing evidence on that front. But what do we do about this affidavit where now this man is testifying as to, oh, everybody knew that there was an accident on the 28th. How do you handle that and tell us it's not weighing?
So because it's an evidentiary burden, the plaintiff carries the burden to make sure that it's competent and substantial, just like they would with any other evidentiary burden. And so regardless of whether we get to, and I'm prepared to talk about it, but I don't think we need to get to the Perlmutter question of whether it's clear and convincing. The burden exists. The plaintiff has to show that the evidence says what the plaintiff says it does.
So under that CSE, it has to be admissible evidence.
So it has to be competent evidence.
Okay.
In other words, a witness can't just testify to speculation, because you could lead. I think the idea that it has to be admissible evidence comes from the trial burden. In other words, would the jury be able to hear it?
Okay.
But this is, could this be evidence that, if believed, would support the proposition, setting aside the rules of evidence? But you can't believe someone who testifies based on, I heard it from other people. Why aren't those other people testifying? I know that's the hearsay rule, which, as we all know, exists for a reason, namely the reliability of the evidence for admission in front of a fact finder, whether at the threshold or otherwise. But I would say that you would analogize that to a summary judgment affidavit, what we call the self-serving affidavits or the contradictory affidavits, the type of evidence that is often proffered at the summary judgment stage that consists of speculation, lack of knowledge, attempts to come back from other testimony, et cetera. That's what we're talking about in this instance. And so that affidavit, for the reasons laid out in the record, he says, as Judge Brownlee pointed out, he says that this was the talk of the town or whatever, but he doesn't really specify. He doesn't say how he knows that was Mr. Sagastume, which of course is a core element of some form of knowledge, just to say, this guy, I've met him before, or I saw him, or they told me that's the guy from CNC who was here the other day. None of that is in that affidavit. And so a reasonable proffer, a reasonable basis would require that evidentiary element as well. And that, of course, gets you also beyond the weighing part of it, because it has to be reasonable. And we define reasonable, again, based on, what our evidentiary standards are with proffers and things of the sort. And so that's why, and this court has said that in different words, but it said that, and that was the second part of the statute I was going to get to, which is the evidence in the record are proffered by the claimant, which is this court said in Mercer, it said we don't take the plaintiff at face value. And I think that's the question that you're asking, both of your honors are asking, which is, what does that mean? What is we don't take the plaintiff at face value? Because of course, absent going en banc, that is your rule. You say we look at this and we don't go face value. And so you have to sort of place some scrutiny on it. And the question is, what scrutiny is it? And the scrutiny we think is most applicable is the same scrutiny that would apply to a plaintiff who's resisting summary judgment, or a plaintiff who's attempting to proffer meet an evidentiary burden of some sort. And again, what that evidentiary burden is obviously subject to debate, as you alluded to, Judge Nardella, is the third aspect of the statute. And before I move on to the third aspect of the statute, I would also like to point to this court's case in Amazulu, which they refer to as Dinkins. Maybe there's more than one Amazulu case, but in that case, they looked at whether the conduct was related to what was going on. And so in that case, it was, marijuana. They found out that the guy was had used.
Wait, we're familiar. I think it's Judge Brownlee's case.
Okay, very well.
I think you were on it too, Judge.
I was.
So we know the case.
Very well. I wanted you to know I was familiar with it. That's part of what I do here, right? Thank you, Your Honors. So I won't go through the facts, but the idea is that when you look at that opinion, you were assessing, the court was assessing what the relation to the conduct was. It's not just other
Yeah,
conduct.
I think that's a fascinating question. What is the fit between the conduct that's being called outrageous, right, to necessitate punitive damages and the actual damages being caused in the case? And I want to hear you say, do you think the conduct that's being called outrageous also has to be part of the little b breach? It has to fit within the nexus of duty, breach, cause and fact, proximate cause, causing the damage. So if it doesn't fit within that nexus, it's not relevant to the consideration.
Yes, I think that's right. I think it has, and the way that I've described it in other arguments on this issue to other DCAs is that it has to be a causal connection. And that comes from some of the Florida Supreme Court tobacco cases where they talk about you can't just sort of smear the tobacco companies. Soffer is one of them, but I don't know that it has that specific language in it, but it's a causal connection. The idea is that because it's punitive, whether it's due process or whether it's the statute itself, which makes it sort of an extraordinary thing, you look at it and say, what is the conduct that we're punishing and what is the proof upon which we're facing that punishment? And so we're not talking about damages, but we are talking about some level of causation or liability in the sense of that conduct. And so again, I would say, you know, the analysis in that Amazulu case is useful in that self, but there's also there's a case out of the 3rd district that says, you know, isolated and out of context. That's in our supplemental authority. They say there's a bunch of memos, you know, Monsanto, which of course, much like tobacco companies, gets sued a lot and has been accused of a lot of things. They said, well, yes, but these are memoranda that are out of context. You have to look at the whole record and figure out whether in this instance, this conduct, in that case, it was a products liability case about a particular component of I think it's a fertilizer, but it's something Monsanto does. And they said, look, they relied on government reports. They were acting in the best way they could, et cetera. And that's why I pointed to that evidence at the beginning of the argument, which is to say that, you know, the defendant in this case was doing things that were not outrageous, as Your Honor pointed out the language. He also says at Appendix 292, again, in his sworn testimony, that this is the first accident he'd ever had. And he goes on to say at Appendix 293 that he says nothing other than parking tickets, which gets you to the whole, you know, driver's license, things like that. And I think that without speculating about why you were asking the question, I think that's the element that we're talking about with regard to all of the evidence that the plaintiff offered, some of it related to this suspended license and whether or not it was valid or whether he was speeding. And again, on the speeding stuff, there is no evidence that he was driving. The only evidence is that he was driving 15 like they told him to drive 15. Nobody did any analysis of how fast he was. There wasn't any accident reconstructions or anything of the sort from which a competent jury or fact finder or scrutinizer would be able to conclude that there's a reasonable basis to say he was driving in excess of speed, whatever the speed limit is. They told him it was 15. We'll assume that for the record.
Wasn't the affidavit that he was driving much faster?
Correct. He's much faster. Exactly. And that's what I mean by no one did an analysis. There's really nothing that would support the conclusion for a fact finder to reach that next level of, you know, what does fast mean? And so again, while, you know, generally lay witnesses can testify to, you know, the car was going really fast. In this instance, you don't have anything that suggests how fast, which of course is the relevant analysis.
Yeah, counsel, if we take away no driver's license, if we take away suspended driver's license in New York, we look just simply at the fact that we have an accident report dated December 28th, which they're going to argue suggests that there was a prior accident that occurred in a substantially similar way, which would have given rise of notice, which then make the conduct outrageous. If we just look at that, and if we were to accept what I think counsel's argument is going to be, which is that the proffer is only something that they can say, and the record is only to be looked at. You can't look at counter evidence. They may say you can't weigh evidence with only the evidence they put in. If you were to accept the parameters, those parameters, is there anything that the plaintiff put into the record which would call into doubt the veracity or the reliability of the December 28th crash accident report?
So I think that first we would look to that affidavit because it's
The Gregory affidavit?
the affidavit that the plaintiff offered, Gregory, because that casts doubt on it because it doesn't have any indicia of reliability. I think that's the first element.
But how does that affidavit cast doubt as to the December 28th accident report?
The December 28th accident report would be on that, you would have to rely on something outside. But again, you would have to figure out whether or not the December 28th incident actually happened, because the report itself, first off, the report itself is not, it's a traffic accident report, so it's not necessarily directly admissible. And I know we've talked about whether or not the evidence has to be admissible, but it has to be evidence upon which a fact finder can rely at some level, whether it's at the threshold or not. And so, because if not, we can just, there's no evidentiary standard. So, and I think that.
Wouldn't they just say, well, they could just proffer, I'm going to show blah, blah, blah.
How would you show it after that is sort of, and again, I don't need to answer a question with an answer, but the next question is, how would you show it after that? And so it's sort of how you get to, with discovery, for example, where we say, look, it doesn't have to be admissible evidence, but it has to be, under the old standard, we've changed that a little bit, but the idea of reasonably calculated to lead, it has to be something that is, a foundation for that. And here that police report would lead you to the typo. And here that that police report would lead you to the testimony of the deputy who said, I was the only one there on that day. I was unaware, this is what happened on that day. The CAD reports, it would also lead you to the job reports as well. And there's also an element of considering what the evidence would be if they were to show it. And without getting into the perlmutter, we lay that out in the brief, and I'm happy to answer those questions either on the bowl or now. The question, regardless of whether or not they have to prove it by comparing and convincing, it has to be reasonable. And I think you don't take it at face value. So even if they proffer it, it has to be scrutinized. And that's really the fundamental element here.
When you talk about the gatekeeping function of the trial judge, when it comes to evidence that they're being considered for punitive damages, obviously they're also a gatekeeper at trial in a different kind of way. Obviously they're a gatekeeper when you provide expert testimony. There's a lot of gatekeeping functions. Some of them are parallel to the case we have here. I guess my question is, what would the foundation that would need to be laid to ultimately get a crash accident report dated December 28th into evidence?
I think you could probably bring in somebody who was there, the police officer, to say that, what they observed.
Would he have to testify that this is a fair and accurate depiction of the accident that I wrote a report on December 28th?
I think that's an element of authenticating the report, is to say that that's the report from that day, sure.
And you would suggest the evidence that you put in, which would say that he can't lay that foundation.
Correct. And that's what I say, that's what I mean when I summarize as foundation for what, or proffer for what, for the jury to consider or the fact line.
Counsel, I ate into your time. I'm going to give you an extra 2 minutes, and counsel, I'm going to give you an extra 2 minutes as well.
Thank you, Your Honor. I'm here for whatever questions you have.
May it please the court. Jeremy Markman on behalf of the appellee Stafford Mitchell. And it's our position that there was no error by Judge Sandor, the trial judge, in this action below in granting the motion to amend to add a claim for punitive damages. Judge Sandor below followed the plain language in the text of 768.72 subsection 1 in analyzing the reasonable showing by evidence in the record or proffered by the claimant to show a reasonable basis for recovery of punitive damages. He also analyzed it under subsection 2 in the abundance of caution, given that the Perlmutter issue is currently before the Florida Supreme Court. I think they had oral arguments in October. I agree with the counsel for appellant on this issue, which is I don't think it's necessary for this court to rule on the standard under subsection 1 or 2 and adopt or reject the Perlmutter standard explicitly by the 6th DCA in this case, because Judge Sandor has found a reasonable basis, a reasonable showing of a reasonable basis for recovery of damages under subsection 1 and met the clear and convincing evidence standard under subsection 2. So either way, it can be affirmed without an explicit finding of Perlmutter or not. But if this court wants to speak to it before the Florida Supreme Court does, it's our position, of course, that the plain language and the text of that language would be undercut by adoption of the 4th DCA standard in Perlmutter. The reasonable basis for showing, as Judge Brownlee, as we're talking about what was shown by the plaintiff as a proffer or evidence in the record, and whether or not the court below can consider the entirety of the record as well as the proffer for appellant. It's our position that that should not be shown, absent, of course, and here's the exception to that, if they can show blatantly false. And that language of blatantly false is found in the Feliciano case out of the 11th Circuit. There's no Florida DCA case that talks about that type of consideration, but the Feliciano case out of the 11th Circuit says only when it's demonstrated that it's blatantly false. And so I'll analogize it, even though the discussion of the standard for summary judgment is not applicable to pleading stage under subsection 1 or the evidentiary stage under subsection 2 of 768.72, because he analogized it to the summary judgment issues. Just like in summary judgment, where if there you don't weigh the evidence. But if something is blatantly false, what has been found to be blatantly false in the DCAs in Florida potentially is evidence of stuff that's on video. Because you can look at it and a picture is worth 1,000 words and that's it. But testimony itself requires weighing the evidence.
But is this testimony? I mean, it strikes me, and, you know, I'm not making findings of fact sitting in as an appellate judge, right? But it strikes me that it's pretty odd that we do have the police officer, and this would be something that's in the record, right? He has said that we have the police officer basically saying this is just a scrivener's error.
Let me correct and point to when he cited to that portion of the record, what it is it's the police officer who did the report on Stafford Mitchell's accident.
Yes, that's
That-
true.
Right.
You have two different police officers. You have
Two
Mr. Charles and Mr. Ron. I'm sure you can pronounce his name better than I can. You have two different police officers doing one bodily injury, doing one property damage. Understood. But I think what Judge Brown is concerned about is you have a December 28th police report by Mr. Charles. And then I have put into the record a certification from a records custodian, which says very clearly that the accident report dated December 28th is dated incorrectly.
What we have though is lack of evidence. We don't have something dated December 28th. Not evidence it didn't happen. It's just a lack of evidence.
We don't have a report dated December 30th. Isn't that weird?
No, we do have a report to say.
It's just not in the-
December 30th. It's not in the record on appeal though, I mean, admittedly, but that's what was generated by that other officer when he testified about.
Well,
the
what-
report
no.
with regard to Mr. Mitchell.
No. That, I mean, I think to be clear, well, it's not on the record. It's not on the record.
Okay.
Yeah.
Okay.
It's,
We'll drop it. But there are, I think there's confusion because as you said, there's two different officers writing two different reports for two different things. And what is odd is I have a report on property damage dated December 28th, and I have a records custodian certification telling me that that date is incorrect. And it is being relied upon in order to amend for punitive damages.
I think what the records custodian is saying is we don't have anything that on that date. I mean, that's the basis of that affidavit. What we do have is we have an eyewitness to the December 28th, who, as a witness who can testify at trial,
Who's your eyewitness, Gregory?
Mr. Gregory, yeah.
Doesn't he say on isn't he the eyewitness to the December 30th, but as to the December 28th, isn't he not just testifying based upon it was well known in the community?
Because it was the same guy on December 28th.
But he's not an eyewitness to December 28th in the affidavit, correct? I mean, let's be really clear, this matters.
Yes, it does.
Okay.
But what we do have is we have evidence that it happened before.
How?
And we have, because Mr. Gregory says that it's widely known throughout this job site that it
How does that
happened
get into
2 days
evidence?
before. I'm sorry?
How are we gonna get that into evidence? Mr. Gregory's not
It's-
gonna sit on a witness stand, correct? This is if it's admissible. Mr. Gregory's
Yeah.
not gonna sit on a witness stand and tell the jury that it's widely known in the community that there was a December 28th accident. He can, right?
He can say, I have heard from lots of people about this and it's not hearsay because it is purely there for notice and for the basis of punitive damages. It's not there.
It's not purely there for notice. It's purely there to deprive them of a substantive right to be free, right?
No, it's not a matter of depriving the substantive right. It's a matter of there is evidence that an accident happened on the 28th. There's a lack of evidence that it didn't happen. It's just, there's no evidence here that it happened versus there's evidence that it did happen. When you, without weighing the evidence, when you say there is evidence here and there's a lack of evidence here, you have to go with the evidence that's here. And so when there is evidence on the 28th, that means that there was an accident that occurred on the 28th. And when we talk about the particulars of that, that is just one component of the reasonable showing with regard to punitive damages. So for example, in your hypothetical, well, in your question to appellant about what if we take everything out about the driver's license and all that, I think the answer to that question was if it happened on the 28th and it happened substantially similar, and then they let him drive again, that alone would give rise to a reasonable basis for a reasonable showing of punitive damages, because you can't speculate as to what a jury is going to do with that evidence, but it rises to the level at least of gross negligence. But when you combine all the other factors that we pointed out of the gross negligence of Sagastume and either condoning or the direct or vicarious liability of CNC corporation, then what you have is you have a reasonable basis for a reasonable showing of punitive damages under subsection 1 and sufficient evidence when you don't weigh the evidence of clear and convincing evidence of that gives rise to punitive damages under subsection 2, even though that's evidentiary. But frankly, when we're talking about this, the pleading standard under subsection 1 is intentionally low. I understand it's a right to be free from financial worth discovery, but getting over that right is not the same standard as being able to prove it and get it awarded at trial. So that what happens at this stage, as you know, is that once the pleading happens, the defense can go ahead and file a motion for summary judgment. And now under the new summary judgment standard, if the trial judge in this court finds no reasonable jury could find punitive damages under the clear and convincing evidence standard, that's when it's applied, but it
That's fair,
doesn't
but
apply at the pleading.
we have case law ad nauseum saying that there's a gatekeeping function to be had. So your rule of that gatekeeping function, your vision of that gatekeeping function at this stage, not at the summary judgment stage, but at this stage is what? What is my trial judge doing as a gatekeeper?
Looking at the evidence in the record that's proffered by the claimant and seeing whether or not that is a reasonable, based upon the language, is a reasonable basis for punitive damages, not whether or not that rises to the level of clear and convincing evidence.
Fair. So
That's-
take away the burden, right?
Mhm.
So we put aside clear and convincing evidence. They have an evidentiary, they have a function to be performed as a gatekeeper. Does the evidence that's being proffered, it has to be related? You would agree with that?
I would agree. I mean, related, yes. When you're talking about the fit requirement that you're talking about there, one is that part of the reason for punitive damages is to make sure that this type of thing doesn't happen again. It's a punitive aspect of it. That's why it's punitive damages. So that it's our position. It doesn't necessarily have to be the causation issue, but in this case, it does relate to duty, breach, and causation on each of the factors, including the driver's license factor, because but for the fact that they didn't check his driver's license, he wouldn't have been driving.
But it's a
That's
different
causation.
analysis depending upon who the defendant is. Wouldn't you agree? It's a different analysis for the employer than it is for the employee.
Of course,
Right.
It's clear in the case law that all that has to be shown for the employee is some matter of negligence, which could mean the negligent hiring or the negligent retention, not checking his driver's license, still allowing him to go out, or the simple fact that Sagastume told his manager in Tampa, I don't have a valid driver's license, and his manager told him, go out on the road anyway, drive from Tampa to Orlando repeatedly, just do it as safe as you can. That alone is enough to show the standard for negligence for the corporate employer, let alone the hiring, retention, and supervision issues that have been cited in the record for that.
But would you agree that if you don't have the report in your favor, that you don't have enough to get to punitive damages just with his driving records and history?
No, and here's why. I will tell you, yes, it helps that with regard to the reasonable showing that he had an accident that was almost identical 2 days before. But all the other issues with regard to the driving record, with regard to the way that he failed to secure the reducer, with regard to the lack of training, with regard to—
But none of that that doesn't have anything to do with whether he has a New York license versus a Florida license, right?
all that has to do with is, because it's in the light most favorable to the moving party, he didn't have a license and should not have been driving. That's the causation connection when you're talking about the fit. But when we're talking about this, we're talking about a truck that's connected to a trailer that has a big concrete pump on top with a big metal arm that's filled with concrete that he knows is dangerous because he admitted he got hurt by it before. He knows it's heavy and he knows it could kill people, and he admitted to all that. And despite that, they sent him out on the road from Tampa to Orlando to likely the largest, busiest construction site in the state of Florida at the time, where 15 miles an hour. And on that issue of speeding, not only does the affidavit say that he was speeding, but there was a finding of fact on summary judgment in the record by Judge Sandor previously on a different issue that also said he was speeding, that he didn't check his mirrors. These are undisputed facts found by the trial court that were used as a basis for the reasonable showing for punitive damages, because the undisputed facts were already found by the trial court of him speeding, of him not checking his mirrors, of him not checking his blind spots, of him violating the directive from CNC in order to do those things in an area 15 miles an hour where he left this big metal arm swinging in the wind that was allowed to hit Mr. Mitchell in the walking area outside of this area. That, knowing that he admitted he had to drive in that area with extraordinary caution, the reducer would likely fall if he didn't secure it correctly. He said, even if you look at the counter proffer, Sagastume said, I tied it with a rope, when the undisputed evidence is that there's a metal lock that makes sure that that reducer, the big metal pipe, stays up, and he didn't do that. So even if he tied it with a rope, that's outrageous in itself when you've got this huge, dangerous thing that's filled with concrete that can swing in a big construction area and
But that
kill
also
somebody.
makes it sound like you're making an argument for like per se outrageousness, right? That there's no, you can't just have ordinary negligence in the context of such a dangerous situation. That instead, if you're negligent under those circumstances, it would just constitute, you know, outrageous conduct that would then give rise to punitive damages. I have yet to see that in the case law.
No, and that's not what I'm saying, but I am saying, for example, when you look at, and they tried to distinguish the Phillips versus State case that found manslaughter in that case, that was the souped up Dodge Super Bee. And what that was a dangerous car that was in a slippery road that they knew was souped up and could ride really quick, that they knew was a dangerous, slippery road, that they drove the dragster on a street where it really shouldn't have been driven that way in drizzle weather-like condition. And that was enough for the culpable negligence standard under manslaughter itself. And so when I'm talking about this, whether it's a souped up car or whether it's a truck with a concrete mixer with a big metal pipe hanging from the back that isn't secured properly, those are the same things. Whether it's a slippery road or a busy construction site, those are the same things. And when those are the same things, that means that at the pleading stage, at least, if not clear and convincing evidence under subsection 2, that's enough to show the basis for punitive damages.
Counsel, what do you think that we should do if we don't adopt Perlmutter, and we assume your argument is correct in that regard, and we accept what Judge Nardella previously articulated as parameters that you would favor that would govern a punitive damages award? We accept those parameters, and then the plaintiff proffers evidence, but it is readily apparent that there is some kind of either blatant falsehood or scrivener's error. There is some kind of problem. Say the evidence clearly states that the sky is green, and we're like, we are all walking around in this world, and I know the sky is not green. Okay, if I have a situation like that, but I am confined to the plaintiff's proffer, what do you suggest a court is to do with a situation like that?
I appreciate that. And here's what I'll tell you is that even if this court were to find under the Feliciano case that the accident 2 days before is blatantly false, which I don't think the evidence shows, I think it would require weighing the evidence. But even if we accept that and the parameters that you're talking about, as far as the plaintiff's proffer, what this court can do, whether it's under Phillips or Eversley or any of the standards with regard to manslaughter and culpable negligence, is they can find gross negligence under the standard, reckless disregard for the safety of others, based upon Mr. Sagastume knowing he doesn't have a driver's license, knowing the little to no training that he had, knowing how dangerous the vehicle itself was, knowing how dangerous the condition was for this particular job site, and knowing how you're supposed to secure the big metal pipe and not doing it is enough for outrageousness. It's not a per se, this is outrageous. These are the facts that you can point to that have the fit in place that go ahead and ensure that there is a reasonable basis for a reasonable showing under subsection 1 for stuff that's outrageous. Because if I said to you, Judge Brownlee, if I said, go ahead, you drive a big concrete truck in a construction area when you've got little to no training and you haven't secured the big metal pipe that's going to swing with what you know is very dangerous, but drive it. And go ahead and exceed the speed limit. Don't check your mirrors, don't check your surroundings, and just do it as you're supposed to. That's more than mere negligence. That rises to the level of outrageousness. And I don't know your experience in driving, your qualifications, but I would say if you were doing that like Sagastume was doing that, that's outrageous. And those were his qualifications. Those were the issues.
Have anything in the record that says he didn't have proper training? And was that argued to Judge Sandor?
Yes and yes, because the evidence in the record is that he got a day where he followed around as a helper with which from somebody who supposedly knew it, and then they gave him the keys. The evidence is that he was a pretty bad mechanic and they made him a driver, and that he's never driven anything like this before except in this job. So that, and there's also evidence in his deposition or in CNC's deposition that they were confronted with, there's a certification in order to be able to report.
Counsel, I want to step out of this case and step back into theory, because if we're going to write on this case, we're going to have to pronounce a rule. And whether we avoid or don't avoid permit, set that aside.
Okay.
The rule, as I see it, that you would want this court to pronounce is that the plaintiff has the opportunity to proffer, the plaintiff has the opportunity to put evidence in the record. That is what the trial judge should consider. If they consider a counter proffer, or if they consider something the defendant puts in the record, that makes it akin to weighing evidence now, which is outside their gatekeeping function. Is that fair?
Yes, with the caveat that I would suggest, which is, first, you say, what is the evidence that the plaintiff has proffered? Does that rise to the level? That's the stage one, okay? Stage two is, does that rise to the level over mere negligence? And stage three is, should we consider the counter proffer? If we do, is there stuff in there that is blatantly false? Otherwise, we don't consider it.
So you
That's
consider the counter proffer or the evidence put in by the defendant into the record to the determination of blatant falsehood.
Only for the determination of blatant falsehood. And I think that's the way that you ensure that right not to be free from financial worth discovery, because when you look at it, we're talking about, for example, the standard that was set forth by, I mean, like Judge White in his concurrence in your decision in the Amazullo case seemed to adopt that same reasonable basis for reasonable showing standard that's straight from the text of the statute without addressing the clear and convincing evidence standard when he tried to do the fit for the marijuana and said, well, we don't have enough to show that he was that high that day.
Counsel, what obligation does an officer of the court have when proffering evidence to put in the whole record? So I know you did the video. We're all aware of the video example. I think that's a good example. Another that comes to mind is let's say a deposition, right? I have deposition testimony as to X, but then I have an errata sheet which corrects the deposition testimony, said I misspoke, it's not X.
Oh, yeah, I think absolutely. As an officer of the court, we have to put in an entire deposition with an errata sheet like that. But does that mean that, and so let's take your example one step further, which is we have one eyewitness who says that the accident happened on the 28th, and we have one eyewitness who was working that day on the 28th who said the accident doesn't happen. The only obligation the plaintiff has in that proffer is to put the proffer in there that shows a reasonable basis for.
Well, how is this not akin to the accident report I have? I have an accident report that said a particular accident happened on December 28th, and then I have a record certification that said dated wrong.
Because you also have the eyewitness testimony that says the accident happened. You have
But the very author of the accident report, kind of like the very person that's sitting for the deposition says X, and then they say not X in the errata sheet. I have an agency which issues a police report that says X, and then I have an agency which comes out with a record certification that says not X.
That what you have is a little different. You do not have the person who authored the 28th, which they could have presented or deposed. It could have presented to the trial court. You do not have the author of that accident report from the 28th that says that that date's wrong. What you have is you have the agency who says we checked our records. We don't see anything there. So it must be a mistake.
Well, they don't just say that. The agency says dated. I mean, I don't have it in front of me, but it's
correct.
Paren, dated incorrectly in Paren.
But that's not the person who authored the report. So what I'm telling you is in the example that you're giving me, it would be if I presented that accident report and there was also a deposition from that same person who authored the report, and that person said, nope, it's wrong, that didn't happen, that would be like the deposition with the errata sheet that I'd have some obligation to present to the court. But what we have is we have conflicting testimony, we have conflicting evidence. Even in their best case scenario, it's conflicting evidence, and conflicting evidence is sufficient in order to give reasonable grounds for punitive damages. Just because it's conflicting doesn't mean that the trial court is supposed to weigh that evidence. They can't predict what a jury's going to do.
So let's say it's an errata sheet and it says X, and then the errata sheet says not X.
Yep.
Not X. Okay. Your conflicting evidence is an affidavit by a gentleman who says, I heard.
Yeah. But that's what it is in their best case scenario, it's still conflicting evidence, which means you got to choose which one it is. Even in an errata sheet, for example, the jury is still allowed to say, okay, originally you swore under oath and you said this, but then later when you looked at it, you said the opposite of this. It's the jury who decides which is true, not the judge. And so at the pleading stage for punitive damages, the judge shouldn't be weighing that, even that evidence in the example you're giving on the errata sheet. They should be aware of it. They shouldn't weigh it, because that doesn't necessarily mean that it's blatantly false. It's still a question of fact for the jury to believe whether or not the original testimony of the errata sheet is true. And therefore, we would ask that you affirm the trial court's decision on allowing a claim for punitive damage.
I have one
Yes,
question.
please.
The summary judgment order on liability, does that become evidence, everything, the findings that are in here, does that become evidence supporting punitive damages? And the reason I'm asking is because in the summary judgment order, it says the defendant was driving at an unsafe speed. It doesn't cite what that evidence is, just says that it's undisputed. I think you relied on that with some of your argument as to why punitive damages is supported. So does everything in here just become gospel and become evidence that can support punitive damages? Or do we need to look behind that and see what was that evidence that the trial court was relying on?
I think it would be the trial court within their discretion, because the summary judgment order is not final. They can always revisit it if they find
It can be appealed. This is not appealable.
No,
right
no,
now.
that's not appeal. No, but
Right.
what I'm saying is it's the trial judge who it would be up to them to look behind and see whether or not it's different. But what I'm telling you from that standpoint is just like the law of the case is the law of the case, the facts of the case are the facts of the case. And that summary judgment order sets out the facts of the case. There's been no motion for rehearing. It hasn't been overturned. I understand it can't be appealed yet, but he found, based upon the undisputed evidence at summary judgment stage, that Sagastume was speeding. So it is a matter of fact for this case that he was speeding. There's no dispute on that, and that provides evidence giving rise to a basis for punitive damages. Just like other findings in there, like not checking his mirrors or disregarding the employee handbook that said that he's supposed to do these things and do a check around to make sure nobody's around. All that is evidence that is undisputed, that is the facts of the case, that cannot be overturned absent some appeal that Judge Sandor relied on because it was undisputed at the time. Otherwise, what would we be having? We would be having summary judgment, and then we'd be rehearing basically summary judgment at a motion to amend punitive damages. Once summary judgment's entered, and it's the law of the case and the facts of the case, unless it's overturned or the judge wants to look behind or there's some motion. Otherwise, that's the facts of the case. And so for the purpose of you writing your opinion, when you look at the opinion, absolutely, you can use the undisputed facts that are found by the lower court as a basis for the reasonable basis for a finding of punitive damages in this case. So thank you, Justice Wozniak, for that. Any other questions for me? Otherwise, I would ask that you affirm.
Thank you, counsel. Counsel Propellant, I'm going to add 2 more minutes.
Thank you, Your Honor. First, before I get into some of the questions that were addressed, I would like to mention, because counsel's already been invited in, we do also the third part of the statute that I was going to address in my initial argument, which is our objection to the finding as the corporate defendant. There's some case law on that we cite in the briefs, but Dean talks about actual knowledge of a high probability of what's going to happen to the plaintiff. There's a high standard for the corporate defendants. Many of the cases that find against punitive damages and go on to say, well, by the way, the LLC defendants or the corporate defendants, you meet that high threshold. I won't address that straight on now, but I want to make it clear that we're not waiving that. Also, to clarify, we're also not waiving the potential placement into the Perlmutter pipeline on the issue. Should you decide it, obviously our position is the clear and convincing standard would have to apply, and that the fourth districts, you should adopt the fourth district should you decide that they haven't made the reasonable standard. I just want to make clear that we haven't waived that. Now I'd like to address some of the points made by counsel. The first is the statute says reasonable, not true. So the blatantly false is extra textual. It's from the 11th Circuit, and again, as I recall, the 11th Circuit was interpreting the punitive damages law in Florida. But having said that, our statute says what it says. If the legislature wanted to say true, they would say true. If they wanted to say credible, they would say credible. If they wanted to say verifiable, they would say verifiable. They said reasonable. And so that invites the gatekeeper status, which I think is what you've been asking about, Judge Nardella. With regard to that gatekeeper status, the eyewitness idea, again, I think it's important. What they characterize as an eyewitness with regard to that first incident is exactly as the panel has recognized. He wasn't there on that first day, so he's not an eyewitness to that. And whether he was an eyewitness to the other separates that out. But in terms of if they're trying to show a pattern, whether it's to get the corporate defendant or it's to prove their claim of punitive damages, that's not there. And as to the summary judgment on liability, as you recognize, Judge Wozniak, we can't appeal that. But we can challenge the evidence's use and show whether it's competent for the different legal standard. The summary judgment standard on liability is under the preponderance standard. So let's get even more into the weeds on Perlmutter. If in fact they're going to use a summary judgment under preponderance standard liability for punitive damages, they got to do a lot more. They didn't do that here. In fact, we've done the opposite by showing the court through the record that the evidence that they're relying on is not competent to meet the necessary standard. So don't let them get away with substituting proof for that they have to present for something else. Lastly, the panel recognized that the plaintiff's rule or the appellee's rule does appear to suggest that there is some sort of, requirement that under certain instances, the gravity of the instance shows that it's outrageous. And that's not in the law. As you pointed out, Judge Bromley, there's no case law that says that the character of a specific act is, and as I mentioned in my initial argument, there's plenty of cases in tobacco and other products liability cases that talk about the things that companies were accused of doing and finding that those have to be causally related with the plaintiff. Again, it's punitive damages, and you have to look at what you're punishing. And setting aside what the quantum of proof is, it does have to be connected to that. So for that and the reasons that we lay out in our briefs, we ask the court to reverse. If there are no other questions, I really appreciate the extra time to present rebuttal.
Did you all argue to Judge Sandor that this was just a scrivener's error that he should disregard?
We presented the argument that the record showed that it wasn't a scrivener's error. And I think the reason was because of the difficulty of the characterization of it in terms of looking at whether the plaintiff is entitled to every inference in their favor. And again, that would get me back to whether or not it's reasonable versus true, verifiable, credible, etc. The language is very deliberate. Our legislature does a lot of hard work, and that's one of the things they've done. So yes, the argument by presenting that what's called a counterproffer, but I don't think it's a counterproffer. It's an element of the record. And I'd also like to point out as to the record that they filed a bunch of the depositions. And so, for example, Mr. Sagastumi's deposition that he wasn't speeding, that he was told to go to that place, that he actually told people he was making a U-turn because he wasn't expecting to have to make a U-turn. That's all in his testimony. They may have filed excerpts, but they can't have some of it. And I think that's what Judge Nardello, you were pointing to, which is the idea that, rule of completeness, whatever the conceptual framework is for that, candor to the court, you have to look at the entirety of it. And I would point back to that, the third district case about out of context memoranda. And that's why it's important to understand the full record.
Can you address the record certification? It's been characterized as it's just saying something is not there. What is the record certification that you guys put into the record show?
So it shows that there was that is a, that was wrongly dated. And it actually says that, and that's the language that you had pointed out. The CAB reports also show that the call for that was not for this particular type of incident on that day. There's 2 calls on that day. And the CAB report that record certification includes says that, these are the calls that happened on that day, and it's not anything like this. And so therefore, we would say that that's what the evidence is, which is that the agency is certified. That's a scrivener's error.
When you have that sort of evidence, right? I have the accident report, and then I have the record certification that says it is dated incorrectly. Is that a weighing function for the jury to see both of those, or is that a gatekeeping function for the judge to say the entire basis of the rules of evidence is the evidence that goes back to the jury must have some degree of reliability?
Correct. It's the latter, Your Honor. It is that the judge has an obligation to ensure that the evidence is reasonable and that the evidence says what.
Right. So you go back to reasonableness in the statute.
I would say reasonableness in the statute. And I will also say that, proof, it's a burden. So you have to have, the evidence has to be what you say it is. And if you say that's the evidence, but the person who is in charge of making sure that that is, and you can't prove something, they say, the way that we prove it is to say that, there's nothing to say it's not true. Well, that's not really a mode of affirmative proof in this context. Again, he said many times that the threshold of the bar was low for pleading. It is not. The case law has been, for decades, has said that the standard is high. And the reason for this statute is that it's supposed to be for the most egregious circumstances. So the idea that this is a low bar is inconsistent with Florida law. And that's why we would ask Your Honors to reverse, because they haven't met that standard. And if there are no other questions, hopefully I've answered your question, Your Honor. If not, I'm happy to talk some more.
No more questions, counsel. I want to thank you both for your briefs and for your argument today.
Thank you, Your Honors.
All right. We're ready to call our next case. I'll give you guys a second to switch out positions. Judge Crawford, can you help me reset it? Good morning, council. Welcome. Our second argument today is Webb Roofing and Construction LLC versus Edison Insurance Company, case number 24-1028. As I said before, it's 20 minutes per side. Counsel for appellant, typically we reserve 5 minutes, but we can change that if you prefer. Okay. Well, whenever you're ready, counsel.
Thank you. May it please the court. My name is Mike Fink from beautiful downtown Fort Myers, Florida. I represent Webb Roofing Construction LLC. Primarily, at this point, one of the owners, 50% owners, Brian Webb, and the other owner is Brandon Jordan. I want to make a couple of points right up front and then clarify some of the issues related to quantum error that may be confusing, by the way, maybe. Number one, this is the quintessential voluntary withdrawal by an attorney representing a plaintiff waiving their fee under the Farrow case. Quintessential. Number two, there is no agreement of any kind in writing, never has been, between Webb Roofing Construction LLC and Fromain and Finch PA. There's no email saying we're going to apply the prior firm contract. There's no communication at all. There is nothing. Having said that, the analysis of the case should begin at the issue of whether or not the attorneys, the charging lien attorneys have, and whether the evidence below satisfies and is sufficient to determine and find that the charging lien attorneys involuntarily withdrew based on something that Mr. Webb did wrong. It's a corporation, it's a company they are representing, Webb Roofing and Construction LLC, not the personal individual owners. And in this particular case, it's simply, there's really not anything there because Mr. Finch never speaks with Mr. Webb after they were signed up and had a meeting. From that point forward, he never has a telephone conversation. They don't write emails to each other. He refuses to have any connection or communication with Mr. Webb because he's only listening to Brandon Jordan, who within a couple months after undertaking the representation, Mr. Jordan sets up a new company, competing company, Re-Roof Plus, competing with Webb Roofing LLC, Roofing and Construction LLC. That proceeds from 2019 all the way to March 2021, when the charging lien attorneys withdraw, and they claim that they have to withdraw because now they've got to communicate. They were required to communicate with Mr. Webb as well, and that because he was part of the management team and owner of 50% of the shares anyway, that meant that they, I believe, what the evidence showed was that Mr. Finch had an issue with, he never wanted to talk to Mr. Webb, period, because of these other issues and issues of control and the issue of the litigation committee having found this $869,000.
Are we taking for granted the fact that Mr. Jordan was named the representative for Webb to talk to the firm or no?
The only person that says that is Mr. Finch. It wouldn't matter as far as I'm concerned, representing, wait a minute, let me back up. I recognize that that's the position of the charge lane attorneys. But it doesn't impact whether or not you should be able to communicate with a 50% owner, or whether or not you should be sending settlement checks to different addresses called for by Mr. Jordan, and whether or not, and this is why my client eventually signs the affidavit saying, hey, you're funneling money to him. The only thing that my client separately, not Webb Roofing LLC, which is of course the client that they withdrew from, is he signed an affidavit saying, hey, you're funneling money over here, and they court went through and of course made them write the check, made Brandon Jordan write the check and transfer the $800,000. I mean, that was done, nothing unreasonable about that. And there's nothing in it that creates, that should be deemed a conflict, creating a conflict by standing up for your rights and saying, hey, this is happening. It was happening. And the second thing is the bar complaint saying, I want him to talk to me and communicate with me, which was essentially dismissed or whatever. And they said, they sent a letter to Mr. Finch. And so they sent a letter to Mr. Webb, carbon copy to Mr. Finch, and said, hey, it's a civil matter. So the bar didn't get involved, but later, of course, Judge Hayes in Naples said, hey, you've got to talk to Mr. Webb as well. He owns half the company. So that's when they withdrew in March of March of 2021. And that's before the receiver even gets put in place. I mean, the way the evidence was presented by Mr. Finch is not, we take issue with whether it was accurate or not, and what was placed in the order by Mr. Finch when he wrote the order of the trial court. It made it seem like the receiver was in and there was more to it. It really wasn't. They withdrew from all cases filed their motion to withdraw in March from all cases. You know, as far as we are concerned, without any communication with Mr. Webb, without anything except for a third party bar complaint that didn't arise to anything and that they didn't file a bar complaint right away or it didn't withdraw, he asked to be contacted. That doesn't seem to me to be anything that warrant or support an attorney withdrawing and getting paid on the quantum merit. And that's a good thing. I just brought that
If
up.
we were to disagree with you as to the voluntariness or involuntariness, I mean, for starters, it sounds to me like that's a different standard of review for us because the trial court made this finding, right? And indeed had to amend the order in order to determine that it was an involuntary withdrawal. Assuming we weren't going to touch that finding, and I'm not making that
That's
ruling
exactly
today,
where I'm going. That's exactly
to
what
quantum merit.
I'm
Okay, can you help me with quantum merit?
I think, and I think the brief is great, but I want to make clear that that the law in Florida is that if a client hires an attorney, whether there's a fee agreement or not, if the client fires the attorney, they get quantum merit. If the fee agreement in this case is valid or invalid, because the case did not settle until after they withdrew, it's a quantum merit matter. So whether the fee agreement is valid or invalid, because the contingency did not occur during the representation, it necessarily leads to solely a claim for quantum merit if they did not voluntarily withdraw. So
You would agree then that they would be entitled to the quantum merit fees?
if they did not voluntarily withdraw, there would be some award of a quantum merit fee, whether or not the underlying fee agreement is valid or invalid, and even if they did not have one. In this case, they had a 10%, and that's how they marketed it. They said, we're going to take your cases, we're going to charge 10%, everybody else is charging more. This is the amount of, this is what the insurance, independent insurance folks were charging to take on a case. But anyway, Rosenberg says that whether the fee agreement is valid or not, the contingency in that fee agreement is the cap. So if they did not voluntarily withdraw, and whether or not the fee agreement is valid or invalid, they would be entitled to a quantum merit fee capped or limited by the contingency of 10%.
But you're saying to us that that agreement is invalid. Like if that,
I absolutely.
if that agreement is invalid, if we don't look at that at all, then wouldn't we just be in a situation where we're looking sort of in a first instance thing without the help of any documentation at a quantum Merowit analysis? Then
that-
why would we also, like, is it bringing in something improper if we were to agree with you that the agreement was invalid under the, well, under Florida case law perhaps, and under the rules? Why do I still have that cap if the agreement's unenforceable?
Because of Rosenberg, because it would be public policy. You should not be able to provide the client, let's hypothetically, provide the client with a invalid fee agreement. And then be able to make a fee higher than what that invalid fee agreement said that you had the client sign. It's a matter of, you can't benefit by making a mistake or providing an invalid fee agreement that doesn't comply with the 4-1.5. They clearly have, they cannot, and they don't have anything that complies with 4-1.5. Now, counsel may say, well, we took in the case. I filed the complaint under Finch Law Firm and personally in June 30th of 2019 against the wrong defendant. By August, Finch and Fromain is going along, and then all other cases are all brought completely under Finch and Fromain. They're all started in fact, Finch and Fromain filed an amended complaint in November of 2019, dropping the good faith covenant cause of action and the deck action, leaving only the breach of contract action against the wrong insurance company. And in fact, it's not corrected until August of 2021, after they have withdrawn and so forth, where the new firm comes in and says, hey, we need to put the right defendant. They sued Florida Peninsula Insurance, and it's Edison Insurance Company that should have been sued. My point is, even if he started it, that's a nullity as far as I'm concerned. But if you didn't think he was a nullity, he'd get a couple of bucks for filing the actual wrong complaint against the wrong defendant.
Well, it happens all the time, right? You see it Allstate Castle Key and some
Well,
Allstate Insurance Indemnity. I mean, it's fairly typical that happens in first party insurance cases is, you know, one umbrella insurance company has multiple.
it's not typical that you sue Florida Peninsula and months later, Edison Insurance Company comes in and answers, changing the pleading themselves, answers as Edison as a defendant in a case where they're not a defendant. That happened. And I'm not even going to get into that analysis, but I like David Loeb's office, who took over later on after Finch and Fromain in August, amended to include, make sure we have the right defendant. At that point, obviously it's pointed out to you. I'm just saying.
Okay.
Maybe I'm getting, not necessarily, it's a little bit of a, I don't want to go on a rabbit hole. It's important, but the point being, everything is Finch and Fromain. There is no agreement. It is, you can't, there's no case that allows you, and no case in Florida, and been doing this 3 years with another roofer. We've been before this court, before in the Massey matter, other matters. There's no case that allows you to take a fee agreement to a new firm with new lawyers, period. There's no ratification cases. There are none. And the law and the rule changed. You've got to have a.
If there had been an email exchange here, would that have been okay? So I have a fee agreement between firm one and that client says, or the lawyer in firm one says, we're going to send these cases to firm two, who we have a relationship with. And the client says, okay.
I have a perfect answer. If the appellate court, meaning justices just like you, decide that that constitutes a fee agreement in writing complying with 4-1.5, I would agree.
Is that what the trial court did here? Because he had all of these sort of acknowledgements back and forth between the emails and then found that these are like, it's constituting electronic signatures, and he makes a finding in that regard.
Certainly, obviously, Mr. Finch wrote exactly what he wanted to write. I don't know specifically what the trial court thought, other than what Mr. Finch wrote, but there is no case that allows you to ratify like that. And there is no email saying, what?
Well, forget if there is no case.
There is
Analyzing
no
it from first
email that
principles.
says
Is that
we're-
wrong?
They did follow through and they didn't charge him. I'm not gonna go into what they really charged, but at any rate, they recovered on many of these cases, signed all the releases as they were requested. That's true. That unfortunately doesn't, in my view, because it's so important that there be a understandable, clear fee agreement between clients and attorneys. And that's why in this case, if it is invalid, then the prevailing is purported prevailing fee provision, which in my opinion, when it wasn't litigated, there was no affirmative relief asked. It was my motion to strike that was actually heard. And somehow we end up with an order that says you get this extra money, this enforcement fees when it wasn't discussed. And it, as far as in my opinion, doesn't apply because that provision in that invalid contract doesn't specifically say we're going to charge you, Mr. Client or Mrs. Client, with what the fees it takes us to obtain these previous fees owed. It doesn't clearly say that.
Counsel, can I
But-
get you back to the email issue?
Yeah.
So is it your contention? I hear you saying there's no Florida case that allows for this.
Right.
Is that one, different because this is a contingency fee, agreement? Like, does that matter? And then number two, which I wish I just started with, because this is the one that's most important to me. Are you saying that this debt, it could be an email that would suffice, but there is no such email that checks all those boxes under the rules regulating the Florida bar?
I'm saying, I brought that up because there isn't one, but if there was one, I would still say we have 4-1.5 and it is and it relates to contingent fee contracts must be in writing and it is standard fee.
So it's just that no email satisfies that rule in your mind in this particular case.
That's correct. And there's not one even presented to attempt to bridge that Grand Canyon of a gap. Period. So as I look at this case, one, it's a clear case of voluntary withdrawal. How can the client be responsible for the attorney deciding to withdraw because he doesn't like the client, doesn't want to deal with the client? Issues between clients and attorneys happen all the time. Somebody complains or says they don't like what you did. These things all are worked through. It's normal. You don't constitute the right on behalf of the attorney to claim that, oh, well, it's a adversarial position. Well, it's his end. He created the conflict in the first.
Didn't y'all agree it was a conflict, albeit after the fact?
I'm glad you brought that up because I believe that what the lawyer meant 2 months later, after they already, and you're very, very astute to have caught that. What is there? I assume the only thing they can say is, was it a waiver? Did they say that they were agreeing with him? I think what he meant was you created all this by how you dealt with my client and vis-a-vis Brandon Jordan and giving all the money to him, sending it to different post office boxes and the checks and not communicating with Mr. Webb. That's what I believe he meant. And by that point, maybe they did, because he was clearly not going to ever talk to Mr. Webb, no matter what judge said it. And even I'm not sure that's in there. There's so many transcripts and so many deputies. I don't know that I want to.
Counsel, you are in your rebuttal time. I just wanted to let you know.
Yeah, so I've got my memory. I'm flashing back, but Mr. Finch said he wasn't going to follow Judge Hayes's order, which was actually started in December, even before the next order where he does withdraw. Judge Hayes, Hugh Hayes, required it by order then, and he said it was illegal or unconstitutional and a void order, so he wasn't going to. He testified this. He's not going to test it. He's not going to talk to Mr. Webb no matter what. And we believe, and I 100% believe. I'm not going to go into the other cases, but there's an issue of if you're going to review my fee, if I'm going to have to give this information through the special litigation committee expert that was hired, CPA, and I don't get to control the fee and do what I want to with regard to the fees because he was not going to remain on those cases. Indeed, he already had Rework Plus with Mr. Brandon, and that he was working for and representing. But to just sort of finish out real quickly is that I had no notice that we were going to talk about a fee agreement in terms of enforcement fees and so forth. It was never in there. It wasn't an issue. There was no argument about it. We didn't discuss it. And that's why the fee agreement, I was dealing with certainly we were dealing with my motion to strike, the issue of the voluntary withdrawal and the invalidity of the agreement, not any claims that the charging lien lawyers were actually making. In fact, it was.
Did you argue that there was some kind of due process violation in that regard?
Yes, I did. I found a rehearing. I said, I didn't know, and it should have been capped under Rosenberg, 409, 7th, 2nd, 1016, Florida Supreme Court, 1982, the year of my graduation from high school. I hope I've been clear, but my perception is obviously I feel like this was not fair, and the trial judge is a colleague of mine, even though he's a Florida fan. I'm a South Carolina fan. None of us are any good at this point. But he simply, the ruling isn't supported by common sense and real facts, because as a client, if you don't have any conversations with a lawyer, you communicate with the bar once, they say it's a civil matter, don't do anything for you. And your lawyer in the shareholder derivative action prepares an affidavit for you to sign related to putting money back in the company to be able to pay for the roofs that you've already agreed to repair. Those several things can't, in my view, as a matter of law, frankly, cannot support that the concept of what required by Pharaoh, that the client did something to create a conflict that now you can withdraw and still get paid in a case that.
Understood. Counsel, you're over your expired
I know.
time. Thank you.
Well, good morning to the panel. My name is Alex Finch and I represent the appellees in this case. I was also trial counsel and one of the charging lien attorneys in the underlying case. It's clear y'all have read the briefs. And first I'd like to open up any questions you might have to direct the time here to what is of interest to you. If
Why would this sort of contingent agreement pass muster under the rules and then the Florida Supreme Court case law stating that contingency fee agreements that don't comply with these rules are void as a matter of public policy and unenforceable? Can you address that? Why does it comply with the rule? How do you get there?
Well, it's not really the issue of the agreement. It's the issue of an added party to the agreement, Fromming and Finch. There's
Who under
no,
the rule was supposed to sign though, right? I mean, isn't the rule clear and express? Sorry. He was supposed to sign it under the rule, right?
he who.
Mr. Fromming.
Not necessarily, Your Honor. The rules say, my understanding rules, and Katz addresses this, is not every associate of a firm has to sign on to an agreement who provides services.
But it's a new firm, right? It's Fromming and Finch, the F and F firm.
Right, this would be a different question if it was an associate. I think everybody agrees with that.
Right, but the testimony for the court from the client, from Webb Roofing through Mr. Jordan and through my testimony was that Fromming and Finch was formed as a staffing arm to meet their increased staffing needs because of a horrendous volume of cases, both from them and other clients.
Can a firm be of counsel to another firm?
Pardon me?
This sounds like a dumb question. Can a firm be of counsel to another firm?
Um,
You could see lawyers being of counsel to another firm, but that's not what happened here, right? An entirely new firm was formed.
no, more practically and appropriately, Finch Law Firm became a part of Fromming and Finch, brought the client and the contract to that firm.
But then that firm doesn't sign your agreement. I can't,
Because I'm interrupting.
no, go ahead.
Because I remain, the testimony is crystal clear and unchallenged, that I remained the supervising attorney, the responsible attorney, and that all attorneys under Fromming and Finch and staff work under my direct supervision. It was me. I remained the client. The client felt I was their attorney, testified as their attorney, and Mr. Webb, the director that was in dispute with Mr. Jordan, felt I was the attorney at all times for the company. That's why when he brought a bar complaint, he didn't bring it against Fromming and Finch. He brought it against Alex Finch because
So then-
it was my client.
Did Fromming and Finch do the notice of charging lien where they filed it or no?
Yes, the charging lien for their file
Yeah.
had the name of Fromming and Finch because I am Alex Finch is a member of Fromming and Finch.
But isn't that problematic under the rule? Like, we've got a firm name, not as how I read the rule, and feel free to tell me if I'm wrong, because this is truly the crux of my questioning. But if then that firm doesn't sign the contingency fee agreement, and that firm is the one that did the notice of charging lien, and that's the firm that is trying to get these fees, I feel like there's the gap missing in the flow chart here.
I believe the Fromming and Finch Law filed the charging.
Right.
Not just Fromming and Finch.
But both firms did, but then how does that get around the sentence in the rule that says no lawyer or firm may participate in the fee without the consent of the client in writing?
Right. I'm the lawyer. I'm the,
Right, I understand you, the lawyer, are straddling both firms, but what about the two firms? Only one
I
of
don't
the
understand the
firms,
question.
only one of the firms signed the agreement.
right,
Correct.
because the one, it was no different than if Fromming, Finch Law Firm had done a name change. They changed their name to Fromming and Finch.
Then
PA.
if it's that easy, then why do the two separate firms file the charging lien?
To provide a vehicle to pay staff and other attorneys through the income from those things, not to create a fiduciary responsibility separate and apart from mine with the client. And that's addressed in the brief in the Freights case and the Buckley Towers case, where an attorney who has a contract with a client moves on to another firm and goes into that firm, sorry, excuse me, Your Honor, the fiduciary responsibility and the duty of the client goes with it and maintains the ability to obtain the fees under that contract. And that's cited, sorry, in the brief, I think on page 441, 442. And the agreement can be modified. There's nothing out there. In the appellant's brief, it says, all cases agree you can't modify. Untrue. That's just not true. There's no case saying that written fee agreement, that's a contingency fee agreement, cannot be modified. It can be modified by agreement of the parties, oral agreement of the parties.
Is
Counsel,
there
if we-
some, oh, sorry. Michelle Della, go ahead.
If we disagree with you that it can be modified by oral agreement, let's say we agree with you that it can be modified, but we disagree that it can be done by oral agreement. We think it has to be done in writing, modification. What evidence would you point to show a written modification?
Okay, as a brief, as in the answer brief, sorry. Thank you, Your Honor. And as found by the trial judge, everything between the firm and the client, everything was electronic. Submission of claim. It wasn't an individual agreement for claim because it was impractical.
Everyone acted as if it'd been modified. I think
No,
that's-
they modified it because they sent it, the firm was formed at the express wish of the client to get more attorneys. Then they sent claim after claim after claim and communicated claim after claim after claim with Fromming and Finch as the one with, and then performed under the agreement, emails also, letters. received and
Yeah,
checks.
I'm clear on that from the record.
So,
But do any of those emails or any of that practice, anything that was going on satisfy all of the requirements of the rule for contingency fee agreements? 4-1.5, I think it is, but.
yes, because the agreement operated under by agreement of the parties was the first agreement, and it was modified through emails and all of those things through assent by the client. When you look at the cases dealing with the UETA, and there are 4 cases within the 4th BCA and y'all are not the fourth BCA, dealing with ratification, adoption of, contingency fee agreements, sometimes signed by no one, sometimes signed by one person and not the other. Where you looked at the purpose of those emails is just assent. Does the
Sorry, are
client
those in the
know?
context of contingency fee agreements?
I'm sorry, say that again?
Are the cases you're addressing in the context of of contingency fee agreement?
All four.
Okay,
It's Font versus Nelson versus Pathmark, Katz,
cats is not, that cats can't be helpful, right?
well, it does in the fact that they address the issue of an email. Katz was a partnership agreement and a referral.
Yeah, but Katz is saying, right, that we're not operating under normal contractual principles here. We're operating under contracts that have to conform with the rules, right?
Right.
And so therefore, the agreement doesn't comply and is void, relying on.
Right, but they
Supreme
addressed
Court
the
authority.
email between the one firm and the other and said it wasn't clear enough to constitute an assent of the parties to that situation. That's where the problem fell in.
So can you pinpoint us to a place in the record where you have a document that sort of saves this case from being like Katz? Like, where is in the record an exact email that you think gets you there in compliance with Rule 4.1.5?
The transmission of all of the cases, the acceptance of and communications to enforce those claims. All of those are email transactions. All of them have to do with a transaction. Remember, the base agreement was a master agreement. There weren't new ones. It didn't become effective until you submitted the claim. That's when the contract occurred. And they submitted all those claims for services under that agreement to Fromming and to Fromming and Finch for services. They agreed to the payments to Fromming and Finch for the services and no separate payments to anyone else, any other law firm. So is there an email saying, hey, we got your new attorney and here it is, and we're going to go under the same agreement? The answer to that is no.
So now it sounds like you're in line with Katz.
No, because what the UETA says is you have to look at the totality of the circumstances, and that if an email submitting a transaction is not meant to be binding with the person whom you're submitting, then you can put in the email, we're not going under this agreement. This is subject to a later agreement to be signed. None of that happened because it was understood, it was agreed upon, and it was directed by the client to use that firm, have more attorneys available to do
Well,
all.
counsel, when you say it was directed by the client, can you point us to the evidence other than my understanding of the review of the record is the client said, we need you to get more lawyers. We need more lawyers working on this case. We have
The
more
test-
stuff coming in.
Okay, but,
Right, not please go hire another firm or please go create another firm.
the testimony from me at trial and from Brandon Jordan, the designated client contact, was we need you to get more lawyers.
Right, which is different from the mechanism. of
One,
how you do
and
get-
then, so I acceded to that request and told and this is all in the record. I told Mr. Jordan, I've got more attorneys, here they are, I formed a firm so that we can provide more attorneys for your cases. And that's what occurred. From that point on,
Right, and
even
maybe
before that,
it's slicing hairs, but you requested to do something and you told him how you did it. He didn't direct you on how to do it, I guess is the point I'm making. It, not here nor there.
well, I don't think a client could direct the attorney to form a firm or to do, so no, the attorney responded to the client's directive that it needed, or statement, complaint, whatever term you want to put there, that no more attorneys were needed, with the assumption being if you didn't get that done, then that business will go elsewhere. So when the client said, I need this to get my cases done appropriately, then the firm, did what the attorney said. There's no question in the record at all. But that Web Roofing, through its designated contact, knew the terms of the agreement, knew the parties doing it, knew who the responsible attorney was, knew that the agreement controlled the financial arrangements between the attorneys, and there's just nothing there. And when you look at the cases, respectfully, they deal with assent, the client knowing. In the Pathmark case, for instance, Font Nelson case, there's emails going back and forth, and the client never eventually agreed with whatever the term was, right? And the problem they found there was not that there wasn't an attorney signature on it, but that there wasn't a client signature, because the client signature showed assent, understanding. No credible argument can be made to this court that Web Roofing, the client, did not ask for it, agree to it, assent to it, and perform on it. The evidence is overwhelming, partly because appellant declined to provide any evidence whatsoever at the hearing.
Do you agree, counsel, this may be a fairly simple question, but if we find that the agreement is unenforceable, your client, you were likewise not entitled to enforcement fees? If
Oh,
there-
you mean a attorney's fees for?
Yeah, they
yeah,
seem like
yeah.
they should be prevailing party fees, but they're not. So like enforcement fees, you sue to enforce this
Yeah.
agreement. You agree that if that agreement goes by the wayside, if we adopted opposing counsel's view of the case, that you're also not entitled to enforcement fees. Am I correct about
Right,
that?
the sole
There's-
ground for.
Yeah, is the
attorney's fees
contract.
and enforcement of the contract.
Okay, so can you address opposing counsel's point that then, my understanding is all that we are left with is quantum merit. And what I am wondering is about this 10% threshold, and if you can address his comment that exceeding that would be improper under Florida law.
Okay, so he cites Rosen versus Levin, or Rosenberg versus Levin. That dealt with a pure contingency fee contract. The contract in this case is what's commonly referred to as the mixed fee alternative contract.
Yeah, but we wouldn't be enforcing the contract, right? We would just be in wholesale quantum merit land
Oh.
because the contract, assuming his view of the case was correct, which I'm not saying, but let's just start there. If I don't have the contract, are they still, should we still be limited by the 10% cap set forth in the contract as he has argued, or no? And why not?
Well, no, because there would be no contractual cap.
But he has stated that Florida law lets him get there because it would be bad public policy to sort of reward people for creating a contingency fee contract that fails to comply with the rules.
Well, in our brief, there are Chandris, a case called Cali.
But Chandris, in
Right.
footnote 4 of Chandris, they say you can recover these quantum merit fees.
Right.
And so you're saying that's just wholesale, they're not cap? I mean, I don't think that it addresses the cap.
It doesn't. That would be, if y'all find that an interesting point, something to write on, because there's no case to address it. There's no.
What about the
there's no
Rosenbaum case?
Addressing, if it was enforceable in a mixed fee, because there are multiple cases say that a mixed fee contract is not capped by the contingency unless it specifically says so. This one does. But there's no case saying, well, what happens when you involuntarily get out and your quantum merit, does the cap apply or not apply?
So you're saying
apply.
Rosenbaum doesn't address that situation?
No, it doesn't, at all. But neither do the cases that lift the cap in a mixed, it's new ground to be plowed for the panel if it so chooses. But in the absence of the agreement, there are 4 Chandris, Hernandez, all cases cited, and all say, go back and figure out quantum merit under the totality of the circumstances. Because we've ruled you don't have an agreement. So if there's no agreement, there's still quantum merit. So that's to address counsel's argument of, well, if you gave this knowingly bad agreement, you're not gonna get rewarded through fees. You don't get any, that's just not the standard. And then you have the cases, the other one's O'Malley, that's cited in the O'Malley versus Freeman. So with an agreement, without an agreement, we're entitled to fees. Without an agreement, then the voluntary, involuntary issue becomes a non-issue, because that only applies when you have a valid agreement. And I'd like to address, unless the board has other questions on this particular issue. The voluntary, involuntary, the whole point appellant makes is you gotta work it out with your client. When you're having a problem with your client, you gotta work it out. You can't just say, I have to withdraw. In their brief, they addressed 4 separate times where the client, through Mr. Webb, accused the charging attorney of intentional torts, intentionally harming the client, malpractice, and they address the email from Mr. St. John acknowledging a conflict. It wasn't just Mr. Pugh, we don't like how you're talking to us. We think you're rude. None of that. You are hurting my company. You are engaged in fraud with another director. Those are far beyond a broken down client relationship. That's an adverse relationship that under the Florida bar rules that are cited within the brief mandated withdrawal. Court recognized that. Secondly, even if it wasn't mandated because of that kind of conduct, couldn't work with them. You're being accused of things, threatened things. That's permissive withdrawal for good cause on the other rule. Either way, if you find that there's a valid agreement, then there is an involuntary termination. And the facts to determine that were before the court and it ruled, and respectively, you're bound by those credibility. He found the witnesses to be credible and the information to be credible. And that's what comes before this court. And lastly, the due process notice issue. They claim that we shouldn't have to pay enforcement fees if the court finds the agreement to be enforceable by throwing a bench, because I didn't know about it. Untrue. And the response to the motion to strike was raised as an issue. And the motion to quantify, it's raised as an issue. That enforcement people they chose not to respond. They chose not to present it.
Was the motion to quantify set for hearing before the court
Yes.
on that day?
Yes.
Okay.
All the motions relating to lien would be heard that day and resolved.
Did they argue specifically due process in the initial brief? Do you recall that? I understand it's below, but was a due process argument made before us? Do you recall?
Not
Just
that
fine.
not that I saw, Your Honor. There were 6 issues raised. Validity of agreement.
Yeah, that's okay, counsel. I appreciate it. I think we're looking at the same.
Yeah,
thing.
no, there's no issue raised or set briefing on the due process issue. And based on the rules of this court and other courts, they waived that. We failed to this court.
Thank you, counsel. Thank you both
Thank
for your
you.
time today and your briefing before this court. We are adjourned.
Have a nice day. Y'all.
You too. Safe travels.
Sorry about beating up your microphone here.
No,
I'm a hand talker.
it's not ours.